This video is presented by the Office of Ohio Attorney General Mike DeWine and was made possible in part by a grant from the Ohio State Bar Foundation. The views expressed herein do not necessarily represent those of the Ohio State Bar Foundation. Please be aware that Ohio's Public Records and Open Meetings Acts are both self-help laws which the Attorney General's Office has no authority to enforce. The content presented in this video is for informational purposes only. For specific legal advice, please contact your legal counsel. It is important to remember that all executive sessions must begin and end within an open meeting. The proper procedure for adjourning into an executive session is as follows. In public session, one member of the board must make a motion for entering into executive session to discuss one or more of the approved topics. After the motion has been seconded and the question called, the board must take a roll call vote of its members for the record. Once the roll call vote has been completed, the board may adjourn from the open meeting and enter into executive session. No formal requirement exists for the board to adjourn executive session and enter back into the open meeting, other than to announce to the public that the board is going back into open session. Currently, a public body may only enter into executive session to discuss the following 8 topics: specific personnel matters listed in the Open Meetings Act, the purchase or sale of property, court action, collective bargaining, matters required by law to be kept confidential, security arrangements, county hospitals' trade secrets, and most recently, local cities and townships may enter into executive session to discuss economic development deals. In order to enter into an executive session to discuss personnel matters, it is not sufficient for the public body to simply announce that they will be discussing personnel matters. Instead, the Ohio Open Meetings Law requires that the public body be more specific. The Open Meetings Act provides that the following specific personnel topics are permitted to be considered in executive session: to consider the appointment, employment, dismissal, discipline, promotion, demotion, or compensation of a public employee or official, or for the investigation of charges or complaints against a public employee, official, licensee, or regulated individual, unless the public employee, official, licensee, or regulated individual requests a public hearing. When making the motion to recess into executive session, a public body does not have to include the name of the individual, but may do so if it so chooses. Additionally, the law does not provide any exception for situations in which the public may easily infer the name of the individual at issue in the personnel matter. We have been discussing executive sessions to discuss single individuals, but Ohio appellate courts disagree on whether this purpose may be used to discuss only individual personnel or also to consider multiple personnel at once. You should consult with your legal counsel as to what the courts in your jurisdiction have held on this issue. Once in executive session for an acceptable personnel topic, in order to comply with the Ohio Open Meetings Law, public bodies must still refrain from making decisions. At times, operating under these restraints may seem to run contrary to normal interpersonal communications or seem unnatural. However, the purpose of the law is to encourage public bodies to operate in the open, and any decision-making must be done in open session. For more information on this topic, please consult the Attorney General's Sunshine Laws Manual, which can be found on the Attorney General's website. We hope this video was helpful to you. Please use the provided link to complete a brief survey regarding this training. We appreciate your feedback.